Welcome to the Smart Legacy Podcast, your resource for protecting assets and securing your future. Hosted by Stockton and Cant, join us as we cover essential estate planning and elder law topics, such as wills, trusts, and Medicaid planning. Stockton and Cant, your trusted attorney advisors in safeguarding what matters most. Hello, everyone, and welcome back to another episode of the Smart Legacy Podcast, where we help you protect what matters most: your family, your assets, your legacy. I'm your host, Glen Stockton, founder of Stockton and Cant, a law office and elder law and estate planning firm here in the Kansas City area. We have offices in Overland Park as well as down south in Gardner. And I'm just grateful you've joined me today. Today's topic is one that I wish every family understood long before they actually needed it. So the title of today's episode is Someone Died. Now what? The estate settlement roadmap every family should know. Now, before we jump into today's topic, I want to share something that I've said before on this podcast because I believe it with my entire heart. And I don't think most people, certainly not the vast majority of people, I don't think they give estate planning the time and thought it truly deserves. Estate planning is not simply filling out forms or signing legal documents. Unfortunately, that is how it is treated way too often by far too many attorneys. In fact, I would say the vast majority of attorneys treat estate planning as if it's all about the documents. You go to the attorney to get the will drawn up, the trust drawn up, and they say, put it in a place of safekeeping, come see me if things change. The problem with that kind of planning is the documents that are created are designed to work at the time they're signed, but they're not necessarily designed to work when they're needed because so much changes. And it's because the focus was all on the documents. And as I've talked about before, it's not just the documents. Those are important, but there's so much more. So estate planning is serious, deliberate, deeply human work because we're not planning for ordinary days. We're planning for the days that change everything. If you lose the capacity to make decisions for yourself, believe me, that's a defining moment. If you or your spouse ever need to enter into long-term nursing care, that will be a defining moment in your life. And when you die, that's perhaps the most significant defining moment of all. We don't do estate planning because we live in fear of death. We do it out of respect for the certainty of death and for respect to the power of death. You see, when you die, what is left undone remains undone. You don't get another opportunity to tell your children why you made certain decisions. You don't get another chance to explain what your intentions were. You don't get another chance to tell your spouse where important documents are located. You don't get another chance to explain why one child receives something different than another. Those opportunities disappear. And if you fail to make those decisions, someone else will. If you don't speak for yourself through thoughtful planning, the law actually will speak for you. The law will decide who receives your property. The law will decide who is in charge. The courts will become involved. The law becomes your voice because you never used yours. And unfortunately, that often leads to exactly what families don't need during one of the most difficult and hardest seasons of their lives. It leads to chaos, confusion, conflict, uncertainty. That's why I believe good estate planning isn't really about the documents, it's about people. I've often said that our goal, as I've said here today, isn't to prepare documents. Our goal is to guide families from uncertainty to peace of mind. Because when planning is done well, we're not adding to a family's grief with confusion and conflict. We're softening grief with clarity. We're replacing uncertainty with confidence. And I honestly can't think of a greater gift than you can give or leave for the people you love than that clarity and certainty and making things easy. Now, today we're going to talk about what happens after someone dies. I've been helping family through estate settlements for more than 25 years. I've sat across the table from widows who never had written a check before because their husbands had handled all the finances. I've met adult children who had absolutely no idea where their parents banked. I've met families who couldn't even find the original will or find the estate planning documents. I've met trustees who didn't even know they'd been named as trustee until after the funeral. And I've watched incredibly capable people become completely overwhelmed. Not because they weren't intelligent, not because they weren't organized, but because no one had ever explained to them or taught them what comes next. And that's what today's episode is about. I want to give you a roadmap, not legal advice for every situation, because every family is different, every estate is different, every trust is different. But there are principles, there are stages, there are common mistakes, and there is a path. And when families understand that path, something remarkable happens. The anxiety begins to disappear. Not because there isn't work to do. Believe me, there is work to do. Sometimes a lot of it. But because uncertainty begins to give way to clarity, one of the things we tell families at Stockton Can't is this: you don't have to know every answer today. You simply need someone who knows the next step. And that's what I'd like to do over the next several minutes. I'd like to walk beside you through what I call the estate settlement roadmap, because estate settlement isn't simply about transferring assets. It isn't simply about filing court documents. It isn't simply about paying the taxes or filing the final tax return. Estate settlement is about helping a family move from one chapter of the life into another with as much clarity, confidence, and peace of mind as possible. And it all begins with something that may surprise you. Slow down. Slow down. It probably isn't what you expected me to say. After all, someone has just died. The phone is ringing, family members are arriving, the funeral home's calling, people are asking questions. Everyone wants to know, what do we do now? And my answer is, slow down. Now, I don't mean do nothing. There are certainly things that need to be done. There are funeral arrangements that need to be made, family members who need to be notified, the home may need to be secured, pets need to be cared for. There's things to do. But what I don't want you to do is confuse important with urgent. Those are two very different things. One of the biggest mistakes I see families make is believing that every decision has to be made immediately. It doesn't. In fact, some of the biggest mistakes I have seen over the past 25 years happened because families moved too quickly. They began dividing personal property. They sold the family home. They closed accounts. They distributed assets, all before they really understood the plan. And I've learned something over the years. When emotions are high, judgment is not always at its best. It's not a criticism. That's simply human nature. You're grieving. You're exhausted. You're overwhelmed. You're trying to make permanent decisions while experiencing temporary emotions. And that's why the first step on the estate planning settlement roadmap is simply this: slow down. One of the greatest gifts you can give yourself after losing someone you love is permission to slow down. Grief clouds judgment. You don't have to have every answer today. You don't have to make every decision today. You simply need someone who knows the next step. Now, before we go any further, I want to make an important observation. Everything we've been discussing assumes one of two very different situations. Either your loved one planned well, or they didn't. And believe me, those are two very different experiences. One of the things I've observed after helping probably thousands of families at this point is this: the experience after someone dies is dramatically different depending upon the quality of the planning that took place before they died. Families who planned well, they still grieve, they still cry, they still miss the person they love. Good planning does not remove grief. Nothing can. But good planning absolutely removes uncertainty. When planning has been done well, The successor trustee already knows that they are the successor trustee. The executor already knows that they are the executor. The family knows where the important documents are located. They've already talked about wishes. They've already talked about expectations. They've already talked about who is in charge. At Stockton & Cant, every client leaves our office with more than a binder full of legal documents. They leave with a roadmap. That roadmap explains what happens next, who should do what, when it should be done, why it matters, and where to turn if they need help. One of the reasons we spend so much time educating our clients is because we don't want the first estate administration meeting to occur after someone dies. The first estate administration meeting actually occurs while our clients are still alive. And we call that the family meeting. We're preparing the family. We're preparing the trustee. We're preparing the executor. We're preparing the children because we know someday they'll need that preparation. So good estate planning does not eliminate grief. Nothing can. But it absolutely eliminates uncertainty when it's done right. And you replace uncertainty with clarity. Families are then free to focus on loving one another instead of wondering what they're supposed to do next. Unfortunately, not every family's had that opportunity. Not everyone has a roadmap. Not everyone knows where the documents are. Not every child knows who has been named trustee. Not every spouse knows where the investment accounts are located. Not every family has had the conversations they should have had. And that's where uncertainty begins. And that's why today's episode is valuable, whether you've planned well or whether you're listening because someone you love has recently passed away. If you've already done good planning, I hope today's discussion simply reinforces why that planning mattered. If you haven't, perhaps today's episode will encourage you to move planning higher on your priority list. As I said earlier, you don't get second chances when you die. What is left undone remains undone. And I can promise you this, the difference between those two families, the ones who planned well and those who didn't, is remarkable. One family spends their time asking, what did mom want? The other family says, we already know. One family spends weeks searching for documents. The other knows exactly where they are. One family argues over who's in charge. The other already knows. One family feels overwhelmed because they're trying to figure everything out. The other simply begins following the roadmap. We don't prepare people for death. We prepare families for what comes after. And that's the difference. Now, whether your loved one had an exceptional estate plan or whether they had no plan at all, there are still some immediate priorities. So let's talk about those next. Because there's a handful of things that every family should do, and a few things I strongly encourage every family not to do. So let's talk about those immediate priorities. When someone dies, there are really two things happening at the same time. The first is emotional, the second is administrative. The emotional side, well, that's obvious. You've lost someone you love. Whether it was expected or completely unexpected, you're grieving. You're planning a funeral. You're comforting family members. You're trying to process the reality that life is going to look different going forward. Then there's the administrative side. Unfortunately, grief doesn't stop the mail from arriving. Bills continue to come due. Financial institutions have procedures. Insurance companies have forms. Government agencies have deadlines. And while those things are important, they should never become more important than the people sitting around your kitchen table. One of the things I tell families is this: don't let administration steal your opportunity to grieve. The work will still be there next week. It'll still be there next month. Take the time to attend the funeral, sit with family, tell stories, laugh, cry. Remember the person you've lost. Estate administration should support the grieving process, not replace it. Don't let administration steal your opportunity to grieve. There will always be paperwork. There won't always be another opportunity to sit around the table and remember someone you love. Now, there are a few things, practical things, that I recommend doing fairly early. And the first is make sure you request a sufficient amount of death certificates. People often ask me, how many should I order? And my answer is usually more than you think you'll need. And while there can be a small cost involved with that, you're going to want those. Banks may require one, investment companies may require one, life insurance companies almost certainly will need one, the Veterans Administration may require one, pension administrators, title companies, the Register of Deeds office, sometimes utility companies. It's much easier to have them than to go back and have to request additional copies months later. So I would say for most people, somewhere between 8 and 15 copies. And if that's more than we need, my thinking is that's okay. And sometimes the need for them come later. So get the death certificates. Another early priority is make sure we secure the home. If no one's living there, make sure it's locked. Collect spare keys. Check windows. Take care of pets. Forward the mail if appropriate. If there's valuable items in the home, make sure they're protected. Not because we assume family members are dishonest, quite the opposite. It's because people remember things differently after someone dies. I've seen it happen countless times. One child says, Mom told me I could have the grandfather clock. Another says, no, she promised it to me. Who's right? Well, sometimes maybe both. We told one child years ago they could have it, and we've forgotten about that. And then it comes up in a conversation with another child. They say they want it, and we tell them they can have it, completely forgetting that we told another child they could have it. And believe me, the children didn't forget. So sometimes no one knows who's right. Sometimes everyone sincerely believes that they are right. That's why preserving everything before distributing anything is almost always the wiser course. Remember, the trustee, and this would be true for executors of wills as well, the trustee's first responsibility is preservation, not distribution. Protect the assets first. Understand the plan second. Distribute later. That simple approach avoids a tremendous amount of unnecessary conflict. The trustee's first responsibility is not distribution, it's preservation. Protect the assets first, understand the plan second, distribute later. That one principle alone can prevent a tremendous amount of family conflict. The next thing I encourage families to do is begin gathering information. Notice I didn't say the next step was to begin making decisions. I said gathering information. Locate the trust, locate the will, gather recent bank statements, investment account statements, life insurance policies, property deeds, vehicle titles, tax returns, business records, military discharge papers, Social Security information, Medicare cards, passwords if they're available. Don't worry if you can't find everything immediately. Estate settlement isn't a sprint. It's not a sprint, it's a journey. You're simply beginning to understand the financial life of the person you've lost. Now, if we've done this planning well, the loved one has pulled this stuff together, made it easy to find so that this is easy, right? Everything's put together. It's with the trust. In our firm, we want to have those things every year. We get updated statements. We're keeping these things because the goal for the vast majority of our clients, the number one goal is to not be a burden. And so, if they've got to go looking for this stuff, if they've got to become a detective, learn where assets are located, who the professionals are, how things are titled, whether beneficiaries have been designated, whether they're jointly owned assets, whether there are trusts. If they have to go find that stuff, if they have to figure that stuff out and play detective, it's more of a burden than had we just made this easy for them and gathered it together. One of the things that helps greatly that we do in our office, and I would encourage you, do this on your own if you're not working with us or if you haven't done this already, but we use an Excel spreadsheet, right? We call it the asset detail report. It's just an Excel spreadsheet. But it's our way of keeping track of what our clients own, how those assets are titled, who the beneficiaries are, how they're taxed. And we get statements to back that up. So here's where all the bank accounts are. We got a checking account, a savings account, a money market, some CDs. And we've got copies of those statements that we can get to. We know how that stuff is titled. We know how it's taxed. Here's the retirement accounts. Here's the life insurance. Here's the real estate. Because every piece of information helps complete the picture. And that's exactly why I think it's problematic when families rush. They rush to start distributing before they have that complete picture. The more complete the picture, the better the decisions become. So one of the biggest surprises for families is realizing that nothing is standardized. Every bank has its own procedures. Every investment company has different paperwork. Every insurance company has its own claims process. Some institutions want original documents. Others accept certified copies. Some require medallion signature guarantee stamps. Others don't. Some release funds quickly. Others take weeks, sometimes months. And families often ask, why is this so complicated? And the answer is actually pretty simple. You're not dealing with one system. You're dealing with dozens of independent organizations, each operating under its own rules. That's why estate settlement feels overwhelming, not because any one task is impossible, but because there are so many moving parts. Estate settlement isn't difficult because one thing is complicated. It's difficult because there are dozens of moving pieces that all have to come together at the right time. And that's why having a roadmap or checklist matters. And that brings me to something I think surprises almost every family. Estate administration really isn't about legal documents, as I said earlier. It's about project management. Think about everything that's happening. You're coordinating family members, coordinating financial institutions, insurance companies, possibly the probate court, accountants, financial advisors, real estate agents, appraisers, beneficiaries, trustees, executors, sometimes business partners, sometimes tenants, sometimes creditors. The legal work is actually only one piece of a much larger puzzle. What families really need is someone who knows how all those pieces fit together. And in Stockton at Cant, that's exactly how we view our role. We're not simply preparing the legal documents. We're coordinating an entire process. We're helping families move from uncertainty to peace of mind. That leads us to one of the biggest mistakes I see families make: waiting too long before asking for guidance. One of the questions I'm asked frequently is, Glenn, what are the biggest mistakes you see families make after someone dies? I could probably give you a list of 50, but let me share a handful that I see over and over again. The first mistake is trying to do everything alone. Now, I understand why people do it. Maybe they don't want to spend money on getting professional help. Maybe they think the estate is simple. Maybe they assume, how hard can it be, and I can do this. And sometimes it really is fairly straightforward, but many times it is not. What starts as a simple estate suddenly involves multiple financial institutions: a house, life insurance, retirement accounts, income taxes, real estate, beneficiaries, family dynamics. And suddenly what seems simple becomes incredibly complicated. And we're having to deal with this stuff when we already have a busy life. So one of the smartest things you can do is to recognize what you don't know. None of us expect someone to know how to administer an estate. Why would you? Most people never do it more than once or twice in their lifetime, if at all. Being named trustee doesn't mean you're expected to know everything. Being named executor doesn't mean you're supposed to already understand the process. It simply means someone trusted you. And sometimes the smartest thing a trustee or executor can do is ask for guidance. All right, another common mistake: making assumptions. I assumed mom's house automatically went to dad. I assumed we didn't need probate. I assumed the trust owned everything. I assumed I could just write checks from Dad's account. Assumptions can be expensive. I've seen people unintentionally create tax problems because they assumed they knew what to do. I've seen families create conflict because they assumed everyone understood Mom's wishes. I've seen trustees unintentionally expose themselves to personal liability because they assumed they could distribute assets before everything else had been completed. Never underestimate the cost of assumptions. Assumptions are expensive. Questions are not. If you're unsure, ask. It may be the least expensive decision you make during the entire estate settlement process. All right, another mistake: poor communication. Sometimes the trustee is doing an excellent job. They're working hard, they're gathering information, they're talking with the attorney, they're making progress, but no one else in the family knows about it. Weeks go by, then months. The beneficiaries begin wondering, what's happening? Has anything been done? Why haven't I heard anything? And uncertainty begins filling the silence. So one of the things we've learned over the years is that communication builds confidence. People are remarkably patient when they understand what's happening. It is uncertainty that creates frustration. That's one of the reasons our estate settlement system emphasizes regular communication with families throughout the process. Not because there's always something dramatic to report, but because people deserve to know where things stand. Silence creates uncertainty. Communication creates confidence, even when there is very little to report. Keeping people informed builds trust. Another mistake I see is focusing only on the legal work. Now, that probably sounds strange coming from an attorney, but hear me out. The legal work is incredibly important. Tax work is important. The accounting is important. The probate process is important. But if that's all you're focused on, you're missing something. Families aren't hiring us simply to prepare documents. They're hiring us because they're overwhelmed, they're grieving, they're trying to make good decisions while carrying an emotional burden that few people are prepared for. Sometimes what they need most is not just another legal explanation. Sometimes what they need most is reassurance. Sometimes they need someone just to tell them, you're doing fine, you're not behind, this is normal, we'll get through this together. I've often thought that one of the most overlooked parts of estate administration is we're not just settling estates, we're taking care of people. Estate administration isn't ultimately about the assets, it's about the people, because every asset belongs to a family. Every family deserves someone who can guide them with both competence and compassion. One final mistake I want to mention, and this one may surprise you: waiting too long to ask for help. Can't tell you how many times a family has come into our office, sometimes, 6 months, 9 months, a year after someone died, and said, we wish we would have come to you sooner. Not because they'd done anything wrong necessarily, but because they had spent 6 months, 9 months trying to figure everything out on their own. Remember what I said earlier. You don't have to know every answer. You simply need someone who knows the next step. And that really brings us to the purpose of the estate settlement roadmap. When families come to our office at Stockton and Cant, we're not just thinking about filing documents or preparing documents. We're thinking about the entire journey. We ask ourselves, where is this family today? What do they need next? What obstacles are ahead? Who needs to be involved? What decisions can wait? Which ones can't? What professionals need to be coordinated? What deadlines are approaching? How do we help this family move from where they are today to the day that we can hand them a completed estate administration and say, you're finished? well done, because that's really the goal. Not simply getting through the probate or through the administration, not simply distributing assets. The goal is helping families complete one of the most difficult chapters of their lives with confidence. And that's what estate settlement is designed to do. In our office, it's a roadmap, one step at a time, one conversation at a time, one decision at a time, until the journey is complete. All right. As we wrap up today, I'd like to leave you with one final thought. Sometimes people hear me talk about estate planning and trust, and they come away with the impression that if they have a good estate plan, if they have a good trust, their family won't have to do anything after they die. Simply not true. Every estate plan requires administration. Every single one. If you die with a revocable living trust, there's going to be trust administration. If you die with a will, there's going to be estate administration. If your assets pass by beneficiary designation, someone still has to gather up the assets, complete the paperwork, coordinate the transfers. There's going to be administration. And if you fail to plan altogether, the law will determine how your estate is administered. The question isn't whether the estate administration will happen. It will. And people are going to figure that out sooner or later, right? They're going to figure out that there's things to be done. House may still need to be cleaned out, readied for sale. Vehicles need to be transferred. Investment accounts still need to be gathered, valued, distributed. Life insurance claims need to be filed. Final bills need to be paid. The final, tax return needs to be prepared and filed. Sometimes fiduciary tax returns must also be prepared and filed. Then the property has to be distributed. Receipts have to be signed. The estate or trust still needs to be brought to proper conclusion. And those responsibilities don't just simply disappear. What disappears with good planning is the uncertainty. What disappears is the guessing. What disappears is wondering. What would mom have wanted? What do we do next? Who's supposed to be in charge? So good planning doesn't eliminate estate administration. It transforms the estate administration experience. It doesn't remove responsibility. It provides direction. It doesn't eliminate the work, just makes the work clearer, easier, more organized, more efficient. Makes those carrying out the work more confident. And perhaps most importantly, it allows families to spend less time trying to figure out things and more time taking care of one another. So the real question is, what legacy will you leave? Because your legacy isn't simply what you leave behind. It's the experience you leave behind. What kind of experience will your family have? Will they spend the first weeks after your death searching for answers or following a roadmap? Will they wonder who's in charge or already know because you've prepared them? Will they spend their time trying to figure out what you would have wanted, or spend their time confidently carrying out the wishes you've already shared? Will they spend their energy dealing with uncertainty or supporting one another through one of life's most difficult seasons? The family you leave behind will one day live with the decisions you make today. Your spouse will live with those decisions. Your children will live with those decisions. And perhaps one day even your grandchildren will live with those decisions. That's why estate planning isn't about the paperwork. It's about protecting the people you love and making it easier for them when the time comes. Thoughtful planning today can spare your family confusion, conflict, and unnecessary burden tomorrow. Your estate plan, or lack of one, will one day speak for you when you're no longer able to speak for yourself. It will help determine whether the people you love are protected or burdened, whether grief is softened with clarity or made even more difficult by chaos and confusion. What is left undone today often becomes what your family must deal with tomorrow. And when that day comes, there's no opportunity to go back and change it. So here's my encouragement. Don't wait. Have the conversations while you're here to have it. Explain your wishes or here to explain them. Answer your family's questions about, whatever they have questions about. Answer those while you're still here to answer them. If you already have an estate plan, pull it off the shelf, review it. Let them know where they're going to find it. Make sure it still reflects your wishes. Make sure your family knows what the roles are. At least the people you've chosen to play the different roles. They need to know what the plan is. So if you don't have an estate plan in place, or maybe it's been years since you've reviewed it, don't put it off any longer. I would encourage you, call our office. Get it on our calendar. We will help walk you through this. There's no fee for that meeting. We're going to help sit down, figure out what you have or what you need. We're happy to serve as attorney of record for those people that have already done planning, and the planning looks good, but they don't have that relationship with an attorney. And so I would encourage you, take us up on that. And together we can build a plan that gives your family clarity instead of confusion, confidence instead of uncertainty, and that peace of mind they're looking for. If you've recently lost someone you love, first let me say, I'm sorry for your loss. But you don't have to navigate this journey alone. Helping families through estate settlement is what we do every single day. We will help you understand the process, we'll help you understand your responsibilities, and we'll walk beside you every step of the way. So thank you for spending this time with us today on the Smart Legacy Podcast. If you found today's episode helpful, please subscribe, share it with someone you care about. These conversations matter, and sharing them helps more families plan well. You can find us on Apple Podcasts, YouTube, and Spotify. You can also visit us at stocktonlaw.com, where you'll find all of our podcast episodes and many other helpful resources. Until next time, plan thoughtfully, protect what matters most, and take care of the people you love. Thank you.
The information provided in this podcast is for general informational purposes only and does not constitute legal advice. Listening to this podcast does not create an attorney-client relationship. Laws vary by state, and this podcast focuses on estate planning and elder law in Kansas and Missouri. If you are located in Kansas or Missouri and require legal advice, please contact our office. Otherwise, consult a qualified attorney licensed in your jurisdiction.